To be honest with you, I think if a case is cert worthy, you take it. That if there's a split, there's a big issue, it's preserved, you take the case. I don't get into, we may not win this or anything. That's not my job. My job is to decide cases of controversy.
So Justice Thomas and the Supreme Court are considering an emergency application which goes against the state of New York's new ammunition background check system. But real quick before we jump in this video, if you think an ammunition background check system is clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is MyBookie. This month, college and NFL football is once again back, and so your chances to win with MyBookie are now available. NFL and college football and a brand new cash out system gives you the option to bet and win on these NFL games and college games if you want to this season. MyBookie allows you to bet safely and securely on all games if you want to enhance that viewing experience. I know some people like fantasy football. I love fantasy football, and some people like to bet on games when they're watching them. And again, it just enhances your viewing experience if you would like. To get started, you can go to mybookie.ag and register for a free account. And when you're ready to make your first deposit, you can use the promo code SCHOLAR to get a 50% deposit bonus for free. Again, use promo code SCHOLAR to claim that free 50% deposit bonus, and make sure you bet responsibly. And thank you again to MyBookie for sponsoring this video. As I mentioned in the intro, in this video, we're going to be discussing a challenge to the state of New York's new concealed carry law and the ammunition restriction and requirements that they put in place through the CCIA. The case we're going to be talking about is called Gazzola v. Hochul, and this case is once again up before the Supreme Court. This case involves a challenge to the state of New York CCIA law, which they passed in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruin. The Gazzola case focuses on the impact that the CCIA specifically has on dealers and gun stores, one of those aspects being the new ammunition background check system that was put in place. These businesses argue that the CCIA is unconstitutional because it violates the Second Amendment and then also the Supreme Court's recent Bruin decision. Now, this whole lawsuit sprung up because of the Supreme Court's Bruin decision. In Bruin, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruin, of course, was that the government bears the burden to prove that their restrictions are based in the history and tradition and text of the Second Amendment. However, despite that decision, the state of New York rushed through the new Concealed Carry Improvement Act, and that was passed just 8 days after that decision. In this case, the plaintiffs originally sought to obtain a temporary restraining order and preliminary injunction from the district court to stop the enforcement and impact of this new law. However, the district court rapidly denied both the TRO and the preliminary injunction in the same order. The court issued the denial without even holding a hearing on the TRO or the preliminary injunction. The plaintiffs then submitted an interlocutory appeal up to the Second Circuit. The plaintiffs sought for the Second Circuit to find that the denial of the TRO and also the preliminary injunction was in fact an error. However, a 3-judge panel in the Second Circuit originally went and reviewed and denied the appeal, saying that the court weighed the applicable factors and found that the district court was correct in denying that TRO and preliminary injunction. In response to that denial by the Second Circuit and denial of the district court, the plaintiffs then submitted a petition for a writ of cert before judgment, and that was submitted to the Supreme Court. This type of petition invokes the Supreme Court's statutory power to grant review of a case before the lower court reaches any final judgment. Ultimately, what ended up happening is the Supreme Court denied that writ of cert before judgment. Instead, the Supreme Court indicated that they would wait for the Second Circuit to decide the appeal before stepping in on this issue. That's not really surprising, especially since the other CCIA cases and other challenges that went up to the Supreme Court on an emergency basis were also denied review. However, in the Antonyuk case, Justice Alito did warn the Second Circuit to review these cases as fast as possible, or else the parties could come back to the Supreme Court on an emergency basis. And in March, I believe these 5 CCIA cases, including Gazzola, did have expedited hearings in front of the Second Circuit. But since then, we've heard absolutely nothing from the Second Circuit, and we've received no decision. So despite the Supreme Court saying that they needed to resolve this as fast as possible, the Second Circuit did expedite the hearings, but they have not issued a decision. In the meantime, the state of New York has put in place the various restrictions and some of the restrictions that are involved in the CCIA, including the background check system, which took effect, I believe, on September 13th. That fact and the inactivity of the Second Circuit has led the plaintiffs in the Gazzola case to once again go up to the Supreme Court on an emergency basis. Gazzola and the plaintiffs there filed an emergency application for a reversal of the injunction denial, and then also they're seeking an administrative stay from the Supreme Court. What this means is that there is an emergency application sitting in front of the Supreme Court right now, and it's asking for the Supreme Court to halt the New York ammunition background check system that they are currently trying to put in place. The emergency application was originally filed to Justice Sotomayor, who is the justice responsible for hearing these emergency applications, which come out of the Second Circuit. That emergency application was filed on September 11th to Justice Sotomayor, and the hope was to get the Supreme Court to step in and grant a stay before this law went into effect on that Wednesday. However, Justice Sotomayor, as the justice responsible for the Second Circuit, she had the ability to either grant or deny the application on her own, or she could submit it to a full court for consideration. Recently, we've seen most of the time these will go to the full court for consideration. But interestingly, the very next day on September 12th, Justice Sotomayor denied the application on her own, so it was not submitted to a full court. That then led the Gazzola plaintiffs to refile and resubmit the application to Justice Thomas. Under the Supreme Court's rules, once the responsible justice denies the application, like Justice Sotomayor did, the plaintiffs can then submit the application to any justice that they want. And of course, they chose Justice Thomas, the author of the Bruin decision. So now there is an emergency application that's sitting in front of Justice Thomas, and he will decide what he wants to do and if he's going to submit it to a full court for consideration. I will say that it's probably not a great sign that Justice Sotomayor denied the application on her own. Now, I know some of you are going to say, well, of course she did. But again, the justices will usually and typically refer these requests to a full court for consideration. I think her outright denial of the application on her own without sending it to a full court signals that she knows that it was probably going to be denied on a full court anyways. Also keep in mind that the last emergency application for a stay that went up to the Supreme Court for consideration, it did not go in the way of the Second Amendment. It was not a pro-2A decision. Recently, you had the ATF go to the Supreme Court in the Vanderstock case and ask for the Supreme Court to stay the decision of the lower court down below, which essentially struck down the frames and receivers rule nationwide. In that case, Justice Roberts and Justice Barrett joined the liberal justices to grant a stay in the ATF's favor. So we've seen already that we've had some justices like Barrett and Roberts join the liberal side and rule against some of these 2A issues. And then also, if you just look at the last Gazzola emergency application and the last Antonyuk emergency application and petitions, the Supreme Court also denied those review. So I'm not saying that this will 100% be denied by Justice Thomas. There's always a shot. But I think right now it's a Hail Mary, and I think maybe even Justice Sotomayor's denial would signal kind of the sentiment of the full court right now, that they're going to leave this to the Second Circuit and to the lower courts to decide these issues before they will step in. But I will say, of course, if this is granted, this would have huge implications not just for this specific case, but also other cases that are currently pending in other states. For example, keep in mind, California also has an ammunition background check system. And there's been a challenge to it, which is the Rody v. Bonta case, and that's been going on for a really long time. Right now, you have the judge, Roger T. Benitez, who's reviewing the ammunition case in California, and he's requested some additional information from the parties so that he can try to make a decision. Again, that's a case that's been going on for a long time. It's been decided before, went up to the Ninth Circuit, then went back to Judge Benitez because of the Supreme Court's Bruin decision, and right now he's gathering some information. But what's interesting is what happens if the Supreme Court does, in fact, grant an emergency stay against the state of New York's ammunition background check system, which is very similar to California's. If they put a halt on the New York ammunition background check system, I would suspect that additional documents would be submitted to Judge Roger T. Benitez in the Rody case saying, look, the Supreme Court halted the impact and the implementation of the background check system in New York. You should do the same thing right here and now in California. So again, all these things interconnect. Something like this would, of course, have broad-reaching implications for other cases, even in California, because California has a similar system in place. So it is interesting to look at. We're definitely keeping our eyes on this, and we're going to see what Justice Thomas decides to do or what the court will do with the ammunition background check system. Again, I'm a little skeptical that they will do anything if they'll step in right now at this time, because the Supreme Court has kind of been hands-off right now, and they're leaving it to the lower courts to decide. But they did give the Second Circuit a chance. They gave them the ability to review the cases. And right now, the Second Circuit has been sitting on those decisions. They are not issuing a decision. So maybe Justice Thomas will look at that and say, okay, now it's time for the Supreme Court to step in because we gave you a chance. Again, all speculation, we don't know, and it's something we're going to have to look at and watch going forward. So if we get any more information on this, I will definitely let you guys know. If you have any questions, go ahead and comment down below, and I'll try to answer best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.